recording now. Okay. Welcome to Expert Views on Alternative Dispute Resolution Ever, a podcast about simplifying ADR in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, PhD in ADR from the University of Brighton, United Kingdom. I'm honored to welcome David Hoffman, a renowned mediator, arbitrator, and attorney. David teaches courses on collaborative law and mediation at Harvard Law School. He also serves on the faculty of the program on negotiations, Harvard Negotiation Institute, where he teaches the Advanced Mediation Workshop, Mediating Complex Disputes. David is the founder of the Boston Law Collaborative LLC. He has handled more than 1,000 commercial, family, employment, construction, personal injury, insurance, and other business cases. Boston Law Collaborative was the 2009 recipient of the American Bar Association's annual Lawyer as Problem Solver Award and the 2010 recipient of the International Institute for Conflict Prevention and Resolution's annual Law Firm Award for Excellency in ADR. His research interests are mediation, negotiation, and dispute resolution. He also has several publications to his name. Thank you so very much for honoring this invitation, David. Let me stop sharing now.
Okay, well, you're very welcome, and I appreciate the invitation.
All right, no worries. So without further ado, let me quickly crack on. The first question is, are employees in the US aware of the ADR options regarding disputes or conflicts that might arise between them and their employers?
I think there's a fairly low level of awareness, except in a couple of situations. So in the portion of the US workforce that's unionized, I'm guessing that a fairly high percentage of the employees realize that if they have a dispute with their employer, there's a procedure in the collective bargaining agreement that calls for, processing a grievance and ultimately going to arbitration if the grievance isn't resolved. But that's right now. That's less than 10% of the U.S. Workforce. Unfortunately, I think it'd be much better if there was a higher level of unionization. But laws in the United States have been interpreted in ways that make it hard for unionization efforts to be successful. There's a second segment of the U.S. workforce that is not subject to collective bargaining. It's not unionized, but where there are written employment agreements that the employees have to sign, and those employment agreements often have provisions that require mediation in the event of a dispute. And if mediation doesn't resolve the dispute, then it goes to a private arbitration. And my guess is that the workers who sign those contracts have an awareness, but maybe not a deep understanding of the difference between mediation and arbitration and what would be involved if they actually needed to use those provisions. And for people who in the United States who are in workplaces without such agreements, either an individual agreement or collective bargaining agreement, I don't think there's a high level of awareness that if they have a dispute with their boss, they could suggest mediation.
Okay, so in essence, what you're saying is that there is low level of awareness, I say. Okay, all right, thank you so very much. So why is ADR more prevalent or popular in the more complex society in this given context, US, than it is in the less complex societies?
It's a very good question.
Yeah.
And let me offer two theories about that.
Mhm.
First of all, in pre-industrial societies in some parts of the world, I think China is a leading example, mediation was widely used at the village level. And in many other parts of the world, there are, sociologists and anthropologists and historians who have discovered that mediation has a long history that we in the post-industrial modernized world were really unaware of.
Yeah.
Often these mediations involved using a village elder or maybe someone who was a religious leader. Often it was a person in authority, but the methods were not necessarily adjudication.
Yeah.
Often the process used was to try to restore harmony and by agreement. So the first part of my answer is that actually there's a lot more ADR out there
Yeah.
in an informal way
Yeah.
in the less industrialized
Yeah.
parts of the world. But the second answer I would suggest is this. The development of modern systems of mediation, arbitration, early neutral evaluation, et cetera, have been primarily a function of the judicial system not working well. Now, I don't think there's a one-to-one correlation there. And I'll give you an example. My understanding is that the backlog in the public, in the courts of India is enormous.
Yeah.
And yet the development of alternative dispute resolution has not been robust. And you'd have to talk to somebody from India to get a more informed answer to the question of why that mediation hasn't become more popular. But I suspect a lot of it has to do with cultural norms of how conflicts get resolved. And it may be that adjudication is considered the appropriate way to do it. Here in the United States, and I think the UK and the EU countries, there's been a tendency on the part of business to look at litigation as way too expensive, way too time consuming. It just doesn't make good business sense. And so that's not the only reason mediation is popular. There's also been a strong incentive coming from the progressive parts of our society that believe that negotiation and people with differing views sitting down to talk together is a good thing for society. But one of the other motivations is the one that I just mentioned, which is that for businesses, ADR makes a lot of sense. And they, paying lawyers very substantial fees to resolve, a small dispute. I'll give you an example. I represented a company that owned a building, a warehouse, and it had a big roof, 6-acre roof. And the roof began to fail in the 9th year of a 10-year warranty. And my client, the building owner, wanted to have the roof completely replaced because it was still under warranty. The manufacturer of the roofing system said, no, we're not going to, replace the whole roof. You already got 9 years out of it. We'll give you 1/10 of the value of the roof. And so therein lay the conflict. Well, we litigated that case for 9 years. And the total legal fees, our side, their side, came to $600,000. And the roof itself, the roof system, the membrane, only cost $300,000. And so $600,000 was spent on lawyers to figure out who's going to pay for a $300,000 roof. Doesn't make sense.
No, it doesn't.
And so I think some of the impetus, not all of it, but some of the impetus is coming from business.
From businesses. All right. Okay. Thank you so very much. And yeah, to add to what you've said about the less complex society, they used to have this form of informal method. Like in Nigeria, we still have the traditional alternative method of settling disputes, before the introduction of litigation, so yeah.
And I'm curious, Chinwe, are those informal dispute resolution processes still in place side by side with litigation?
Yeah, it is in place, honestly. And then what the LMDC has done, like the Lagos Multi-Door Courthouse has done, is that they kind of used, those methods of settling disputes, like the mediators and recognizing the African culture when it comes to greeting elders, and they use that doing their mediation, to respect elders and to kind of make them feel at home, and they can speak their language, and also they can speak the language. If the mediator is from let's say Lagos, they can speak Yoruba, or if it's from an Enugu state, mediation center as well. So these are some of the things they've added. And also they've kind of incorporated the Igwes, that's the kings of the villages, to train them to as formal mediators, so it's still very much alive. But the problem is that a lot of people still use litigation, and this is one of the things my research dealt with, about advocating about these benefits of using ADR, I suppose going straight to litigation, so yeah, it's still very much alive in Nigeria. All right, so the third question is, to what extent are employees in the US encouraged to use ADR to settle discrimination or bullying and harassment in the workplace?
There's a pretty well-established system of adjudication for discrimination cases in the United States and in other parts of the world, of course. Here, both the national agency, the federal agency, the EEOC, and the state anti-discrimination agencies have mediation programs. And so if a case is filed, if the case is found to have enough merit in the allegations to warrant processing the claim, generally speaking, the participants are offered the option of mediation, and occasionally they are ordered to at least try mediation. Now, one of the principles of mediation is, of course, because you're an expert in the subject, one of the principles is voluntariness. People are required to stay in mediation until they have an agreement. It's not a voluntary process. But interestingly, many of our courts and many of our anti-discrimination agencies have a procedure where they can require you to at least try it. And after trying mediation, giving it a reasonable try, you can go. Now, this raises an interesting policy question, which is, if mediation is confidential, then how do these agencies, or the court for that matter, enforce the obligation to try mediation in good faith? Because they're not allowed to inquire about what happened in the mediation. So there's an unresolved tension between confidentiality and policies that want to encourage the use of ADR.
Okay. All right. Thank you so very much. So what is the way forward for mass awareness on the benefits of utilizing ADR in settling disputes or conflict in the workplace?
Yeah, so I think that there are several ways that we can do a better job here. So one of them begins with elementary school.
Yeah.
I think that the schools would benefit not only from having training in negotiation and conflict resolution, but also peer mediation programs. And many schools in the United States, not the majority by any means, but many have peer mediation programs in which students are trained in how to mediate conflicts among the other students. And I think that's excellent training both for the peer mediators and also for the other students. Second, I think employers could do a better job of educating their employees about dispute resolution options and implementing policies. So for example, at my office, Boston Law Collaborative, we have an employment policy that says that if there's a conflict, if there's a dispute, we agree to go to mediation, and Boston Law Collaborative will pay 80% of the cost and the employee will pay 20%. Fortunately, we've never had to use this policy.
Really? I was about to say that's a good incentive.
Yeah. And then the policy also says that if we don't resolve the conflict in mediation, then one option is arbitration. And the policy says that we only go to arbitration at the option of the employee. So in other words, as the managing member of Boston Law Collaborative, I cannot require any employee to go to arbitration. If they want to go to court, they can go to court. And again, we've never had to use that policy, but I think there's a lively debate in many parts of the world, certainly a very lively debate in the United States, as to whether mandatory arbitration is a good idea or not. There are consumer contracts, there are employment contracts, every kind of banking contract, you know, if you take out a bank loan, throughout the economy of the United States, mandatory arbitration has now become quite common. And it's been very controversial in the area of sexual harassment. So my own personal belief is that the less powerful party, the employee, should have the option to insist on arbitration if they want it, and the option to go to court if they want to go there. And I don't think there's anything wrong with an employer obligating itself to go to arbitration if that's what the employee wants.
That's a good idea. How about the court-connected ADR, the multi-door courts? Because in Nigeria, they can refer parties, you know, to mediate.
Yes, it's wonderful to hear in what you said a moment ago that in Lagos there is a multi-door courthouse. Which was an idea that was created by Professor Frank Sander. And Professor Sander was my advisor in law school, and he became a friend. Sadly, he's passed on. His idea for multi-door courthouse, where someone shows up with a conflict, the courthouse serves as a triage center and sends them off to mediation, negotiation, arbitration, etc. Appropriate, or to a village, you know, informal dispute resolution system. It's a great idea, and it has not been widely adopted. And think that one of the reasons it has not been widely adopted is a lack of funding, at least in the United States. And I think this is true in many parts of the world. The last, I would say, 30 years or so, we've seen a major retreat from public investment in public institutions. Part of that's been fluctuations in the economy, but part of it is from my vantage point, a conservative tendency to favor private institutions and as opposed to public ones. And so the idea of giving our court system more money so that the court system can then hire mediators and hire evaluators, which I think would be a terrific thing. It's been very hard to get traction for that idea. So I hope the pendulum will swing in the other direction at some point. And people will realize that it is a wise use of public funds to reduce the dependence on lawyers and trials and 9 years of litigation over a simple roof case.
Yeah. Oh, wow. We've utilized that in Nigeria. Almost all the states in Nigeria have got multi-door courthouse. So and they've settled so many cases, but still we from the research I conducted, I know that there are so many more people that are yet to utilize or embrace ADR, especially the lawyers, because they think it's a drop in their revenue, so they've not started utilizing ADR in the sense that they don't encourage their parties and the parties or their clients to use multi-door courthouse. But so far so good. There's so much advocacy going on, and yes, within maybe 2 years or 3 more years, so many people in Nigeria would start utilizing that.
Well, and to go back to one of your earlier questions, in addition to teaching school children, we should make ADR a mandatory subject for lawyers.
Funny enough. Oh, sorry, can't carry on now.
And we should put it on the bar examination so people can become a lawyer without having studied it.
So that's one of my recommendations for my thesis. Primary schools and secondary schools. Some universities in Nigeria they've not yet made it compulsory, mediation compulsory, but they sort of is an elective. But my recommendation was for primary school students, secondary school. So the need for a balanced story, like litigation, everyone knows about litigation, even from the home front, parents should also start educating their young ones, their kids, on the about the benefits of ADR. So fingers crossed, dude.
Well, when you think about the popular media, and what impression do people have of lawyers and conflict resolution? They see programs about courtrooms and trials. But they don't see shows about mediators. Conflict. There was a show in the United States called Fairly Legal that ran for 3 seasons and then it died. And it was a show all about a mediator. But it seems like the popular taste, they find conflict more entertaining
than peacemaking. And that's so that's why I must commend you, because I saw your YouTube videos and all that, and then oh god, okay, we're running out of time. Okay, so so let me quickly go to the what is your advice for people who want to pursue a career in ADR?
Well, that's a very good question, and unfortunately we don't have an established career path. I mean, if someone wants to become a doctor or an architect, or even a lawyer for that matter, the path is you get certain kind of schooling, and then you apply for an entry-level job. That's true for academics. You get certain degrees, and then you apply for an entry-level job. Well, in the world of dispute resolution, we don't really have an entry-level. We don't have very many entry-level jobs. We have a few. We have a few. So there are a few public agencies that have mediation offices, and they sometimes hire people. We have nonprofit and even some for-profit dispute resolution firms that hire administrative people. And sometimes you can transition from an administrative role into a dispute resolution role, but that's very hard. Most of the private mediation and arbitration work that's done in the United States is done by people who are lawyers or retired judges who have a certain number of years of experience managing those kinds of conflicts. Now, there's some exceptions. For example, in family law, which is mostly divorce, there are many therapists and couples counselors who become mediators. In the labor management setting, there are sometimes people who are experts in labor relations, but they're not lawyers. And they can get jobs as arbitrators and mediators. And in the environmental law area, many of the mediators are people who are not lawyers, but they have a very substantial expertise in the technical areas of environmental conflict resolution.
All right, thank you so very much. So one more question. We just have 7 minutes. Can you tell me more about the program you carry out at Harvard Law School and Boston Law Collaborative LLC?
So I want to mention 2 programs. So at Harvard Law School, there is a community mediation program called the Harvard Mediation Program. And it's quite unique because it trains students in how to be mediators, and it also provides training for community members in mediation. And so the panel of available mediators at the Harvard Mediation Program consists of both students and people who are not students. So I think that's a good mix. And it provides services for low-income individuals in the district court and the small claims court. So that model of service for people who can't afford to hire mediators is extremely important. And there are thousands of community mediation programs all over the United States. And unfortunately, they're not well funded. Most of them get no public funding. And so they have to do fundraising to support these volunteer efforts so they have enough money for administrative staff. I'm very proud of the fact that Harvard Law School has a very robust, very successful community mediation program that serves the public. At Boston Law Collaborative, one of the things that we did is we created a separate branch of BLC called the Boston Law Collaborative Institute. And the Institute's purpose is to provide training and workshops in a variety of areas that are related to dispute resolution. And one of those areas is diversity, equity, and inclusion, implicit bias, and how to make the world a less prejudiced, less biased place. We also do workshops on mediation skills. And I recently offered a workshop called Law as a Spiritual Practice.
I just registered for it.
Oh, you did? Oh, good. I'll look forward to having you join us for that conversation. Because I think most people think of law as anything but a spiritual practice. But I believe that the spirit of service touches, at least for me,
Yeah.
touches the values that I consider spiritual and very important.
Yeah. All right. Thank you so very much, for giving us a master class, because I know others would be listening to what you just said, hearing on this discourse. I'm so very grateful. And also I must really commend you, like I've said before, on all the great outstanding contribution you've done on the mass advocacy or awareness ADR. This is what we need, because there's so much chaos and acrimony when you use litigation, whereas this is peaceful. People can still reconcile, carry on doing business with each other, and their relationship as well. So, I mean, why can't people utilize these many benefits associated with ADR? So I'm glad that you've been doing the work, and I intend to follow your footsteps. All right.
Well, it's been a pleasure talking with you.
Yeah. And also I would like to invite you again to talk about the collaborative law.
Sure.
That you do, because I've read about it, but I would, I would want to have a master class with you on that, on the collaborative law you teach in Harvard. So thank you once again. And to my listeners, thank you so very much, and stay tuned for the same topic on ADR and workplace conflict. All right. Cheers. Bye-bye. Take care. Bye. Oh, sorry. I need to stop right